Good morning, everyone. My name is Rick Kitson. I'm the Director of Communications for the Cupertino Chamber of Commerce. This morning, we are here to talk about one of the more difficult business decisions people have to make, and that is to end their business. We're pleased to have with us Vinod Nishani, who has previously shared information about how to go through this very difficult process. And with no further ado, I'd like to hand the meeting over to Mr. Nishani. Vinod, are you there?
I am here.
Great.
And I'm getting my video on. All right, good morning. Well, almost good morning, everyone. My name is Vinod Nishani. I'm with the Nishani Law Firm, and this is a presentation called An Overview of Bankruptcy from Small to Medium-Sized Businesses. The presentation is, I wouldn't say a follow-up from my last one, but more of a further simplified view of bankruptcy. I picked a few key areas to touch on the various aspects. Basically, in the time we live in, there's many unknowns, but I know there's a lot of financial difficulties for individuals and companies right now that may not hit right away, but could take shape within the next 30 to 60 or even 90 days. So we'll go ahead and get started. Questions, I guess, can be sent over, and I'll try to answer it to the best of my ability. But let's go ahead and get started with the slides.
All right. Let me get that up for you.
Okay. So the first slide, just disclaimer in the beginning, this is a general overview of bankruptcy law, and it's for informational purposes only. An attorney-client relationship has not been created. So I'm sharing some information, but if you want me to be your attorney, we have to sign an agreement and you have to retain my services. All right. Okay. Let's start with the scariest part of the whole process, which is hiring an attorney. I don't like attorneys. I don't know many people who do like attorneys, but they're not that fun. So when I say the scary part, meeting with the lawyer, you can imagine that you're in a position right now where you're emotional, you're stressed, you're worried how you feel, you're worried what people think, and then you have to go meet a lawyer and discuss bankruptcy. That's not the nicest feeling. And then even though you don't know that lawyer, you don't want him or her to judge you, or you don't want him or her to tell you what you did wrong. You're going to meet a lawyer to find out what your solutions are and what are your options. Now, in the bankruptcy world, it's not just one lawyer does it all. There are lawyers that do patent law. There are lawyers that do personal injury. There are lawyers that do real estate business. You have to find a lawyer that practices in the area of bankruptcy. Now, there are lawyers that focus only on consumer bankruptcy. That's when an individual or someone who has a business, a sole proprietor, there's bankruptcies that only some attorneys handle that. There are some attorneys that do bankruptcies for corporate entities, such as corporations and LLCs and LLPs. That's a business bankruptcy lawyer. There are law firms that specialize in all aspects of bankruptcy, which could be consumer bankruptcy, business bankruptcy, or bankruptcy litigation. And then there's lawyers that have handle all the sides of bankruptcy, but also handle some related litigation involving state court issues, such as my office. We handle all bankruptcies, but we also handle related state court litigation. Now, bankruptcy is part of the federal court system, and then there's also a state court system, which a lot of business disputes can be handled in. My office handles disputes in state court involving business disputes, real estate disputes, and then we handle litigation and all bankruptcy filings in federal court. Now, another aspect you want to understand of bankruptcy when hiring an attorney is in bankruptcy, there's two sides. There's the bankrupt, which is called the debtor, which is where an attorney only represents people or companies that file bankruptcy. Then there's an attorney who only represents the creditors, and the creditors are the ones that are owed money or owed something from the bankrupt party. So if it's a very small consumer firm, they probably don't represent creditors. My office, you represent the debtors and the creditors, and it really depends on the lawyer you're looking for and what your situation is. So you want to kind of understand that scenario, or maybe ask your attorney, the one you're interviewing, what his or her experience is, and what is a percentage of her maybe debtor representation, business representation, and what kind of information she needs to understand you better. Okay, so that's the scary part. Now, what to bring to the meeting? In most cases, a bankruptcy revolves around financial situations. So you're going to need your individual taxes or your company taxes, a profit and loss, a list of all your assets and liabilities. What I would do before meeting an attorney is gathering maybe your latest filed tax return. If you're an individual, maybe 90 days of your pay stubs. If you're a business, maybe a profit and loss or a balance sheet. But in the end, what the picture you want to paint for this attorney is going to be what is your liability, what do your liabilities look like, and what do your assets look like. So that's kind of the draft information you have to take to this attorney, because the attorney has to analyze based on that and based on the information, what is the correct bankruptcy chapter and whether or not bankruptcy will be successful for you. Anybody could file for bankruptcy, but the question is whether or not it's effective and successful for you. That's the question. It is a strategy move, and in the end of the day, you're trying to walk away from large amounts of debt or trying to reorganize a payment plan for that debt. So you want to be able to paint that financial picture. Now, in the current times, many businesses are suffering because the landlord is not working with them. They can't afford their monthly landlord payment, and this landlord doesn't understand the situation. So when you meet with his attorney, you have to be able to explain to him, look, this is the cash flow. This is why we can't afford our monthly lease payment. What do you do? Or an individual who's unemployed, you have a large amount of credit card debt. How do you pay it? So these are financial understandings you want to have before you meet with the attorney. I'm sure he or she will tell you that, but it kind of streamlines the situation once you get there. Okay, do I go to court? In most bankruptcy cases, you'll go to court maybe one time. Now, there is something called a meeting of creditors, which is where you and your attorney would attend. Now, if you're an individual or represent a business, you'll go to this meeting of creditors. And that's not in a court, that's actually in a meeting room. And that's where you meet this person called a trustee. The trustee investigates your assets and liabilities. He or she wants to know what she can find, and she wants to know what assets she can find, and she wants to know you're telling the truth, and she wants to know that everything you have has been investigated, and whatever assets you have will properly be distributed to creditors. Okay, so that's more of a meeting room. The court, you would maybe go one time depending on the situation. Now, this is only involving a bankruptcy filing. This is called a petition for bankruptcy. If there's a lawsuit that happens within the bankruptcy, then what happens is it would be like any other lawsuit. You would go to court, you maybe go call for a deposition, for hearings, whatever's required by the judge, or a personal appearance by the client or plaintiff or defendant is required, you would attend. So it would depend on the situation. So you're gonna have to go somewhere, I mean, we just don't know yet where. Next slide, please. Okay, what is bankruptcy? How do I know if my company's bankrupt? How do I know if I'm personally bankrupt? Well, the simple answer is if your liabilities exceed your assets, you can be considered bankrupt. You don't have sufficient resources to pay your liabilities. Now, there's different type of liabilities, different type of debt that's discussed in bankruptcy. You have secured debt. Secured debt is something that's connected to an asset. For example, if you don't pay your mortgage is secured to your property, and that can be foreclosed on. Or if you're a business and you have a lien and you have secured that lien against all the furniture and equipment in your business, if you don't pay that lien could foreclose on the assets of your business. Maybe you gave them your accounts receivable, maybe you gave them your furniture, depending on the situation. they could take that. That's secured. Priority debt is a debt that's not really connected to anything, not secured, but it's held to a higher standard of debt. And this could be like taxes. Taxes aren't really secured against your property, but they do have, and this is income tax with the IRS, not property taxes. This could be something that's considered a priority debt. And then you have unsecured debt. Unsecured debt is your credit cards and different forms of debt that are not connected to anything, not connected to any property, and also not connected to a priority debt such as the IRS. Okay, so those are the debts that are important to understand. What does bankruptcy protect me or my company from? Bankruptcy can be used for numerous situations. It can be used when you have an individual has large amount of debt and they need to file a bankruptcy to stop the collections. It can be filed to stop a lawsuit that's pending or to slow down a lawsuit that's pending. It can be filed to stop a foreclosure. It can be filed where a company is suffering financially and needs time to reorganize or pay their vendors and creditors a certain amount of money to continue. There's numerous situations it can protect people or companies from. Can you file bankruptcy as many times as you want? No, you can't. So one distinction to understand between a company filing bankruptcy, such as a corporation, or an individual filing bankruptcy, is an individual gets something called a discharge. The discharge means, look, I have completed my bankruptcy and whatever debt's not being paid is discharged. So you can walk away. So once you get that as an individual, you can't just keep filing as many times as you want. There are limitations and timeframes of when you can file again and get a discharge again. So that's something to review and understand. And that's something you discuss with your attorney to plan that, hey, if you're going to file and you get your discharge, you could lose that option down the line. So it's not a free-for-all. And then companies don't get a discharge because they can't really want to run away from their debt. What happens is it's calculated as to whether or not there are assets and how much a creditor will get paid. So there's no such thing as a discharge for a corporation or LLC. If I'm going too fast, somebody send a message and let me know. Can someone be sued while in bankruptcy? Yes. So a regular lawsuit in any other court is just a regular lawsuit. But in bankruptcy, it's something called an adversary proceeding. Now, what happens in bankruptcy court is there's a dispute between finances. So for example, if I were to give somebody a loan and they asked me for financials and I gave them fake financials, I can be sued in bankruptcy court and they can argue, look, that loan that he's trying to run away from in his bankruptcy, the only reason we gave him that loan was because he provided financials and those financials were fraudulent. Therefore, at the end of his bankruptcy, he shouldn't be able to run away from that debt. So that's somewhere we could argue fraud. Also, if there's a dispute as to how much money is owed, if I believe I'm owed $10 and somebody else believes they're owed $20, we can have a hearing on that and kind of a mini lawsuit on that and figure out what the actual number is. So there's different disputes that could come up within bankruptcy, which could be started through a lawsuit or which could be started through some kind of objection. Okay, let's go to the next slide. Okay, so these are the 3 chapters you're going to find for individual bankruptcies and small business. Now, as a reminder, when I say small business, what I mean is that individual is doing business in his or her name. He has not formed an LLC or a corporation. It's more of a DBA or somebody else just doing their business, such as like Mickey Mouse doing business as Mickey's Dry Cleaner versus Mickey Mouse doing business as Mickey Mouse Incorporated. So this is just for the individuals. Now, these individuals are limited to 3 forms of bankruptcy. You have a Chapter 13, which is called a wage earner bankruptcy. You have a Chapter 7, which is a liquidation. And you have a Chapter 11, which is for individuals with small business. Although you usually hear it apply to corporate entities, in the Valley and certain areas, the Chapter 11 could apply for an individual and a business. A Chapter 13 is really for the solo businesses and the self-employed. And the goal is to allow the debtor, the bankruptcy filer, to create a payment plan to pay back his or her debt over a time period, such as 3 or 5 years. And within that payment plan, what we're trying to do is pay back all the secured debt, remember, which is the home, which is behind on the home or anything related, to pay back all the priority debt, which is the taxes, and pay a percentage to the unsecured debt. And that percentage that gets paid back to the credit cards or unsecured debt is based on the assets of that individual. So if the individual ends up having $150,000 in equity in his house and he owes $100,000 in credit card debt, more likely than not, he's going to have to pay $100,000 of credit card debt over 5 years in a payment plan. Now, there's going to be limitations such as homestead exemptions and other issues, but more likely than not, if they got a huge equity cushion in their house, they're going to have to pay for that unsecured debt to maybe 50 cents, 60 cents on the dollar, or even 100 cents on the dollar. It would depend on the case. Chapter 7, again for individuals and small businesses, is a liquidation. What that means is that the person filing bankruptcy says, look, I don't have anything and I don't care, you can have whatever I have, but I have no money to pay anybody back. Now, sometimes people worry what that means is that you have someone coming to their house and, taking their furniture or TVs or couches. That doesn't matter because those certain items are protected by an exemption. So a certain assets and certain amount of money is protected for that individual. So, they're not going to come to your house and steal your TV or your couch, and you can keep 20,000 some and some change in assets. So you can keep cash or car, equity or whatever. So there's certain things you can keep, but beyond that, you would have to come up with money to pay for it, or the trustee would sell it and they would have that extra funds pay some of the creditors. So the difference is the assets can be kept in a 13 because you're paying a payment plan. In a 7, those assets are sold and paid to your creditors, if that makes sense. Now, Chapter 11 for individuals and small businesses is very similar to Chapter 13. However, the difference is Chapter 11 is much more expensive. Attorneys get paid hourly, and also the Chapter 11 is really a very, very transparent, intensive monthly analysis of bankruptcy. For example, in a Chapter 11, a person will need to file a monthly report to the court showing all the money coming in and all the money coming out of their bank accounts. So it's full transparency. And a Chapter 11, the only reason an individual, the biggest reason an individual who can be in a Chapter 13 would go to a Chapter 11 is because his secured debt, such as loans on property and other items, exceed $1.257 million, or the unsecured debt exceed $419,000 and some change. So these numbers, if in the 13 they're exceeded, this individual has to file Chapter 11. Chapter 13s can range from $5,000 to $10,000 in attorney's fees, where there's a down payment and the monthly payment to the attorney is actually paid through the Chapter 13. Chapter 7 can go up to between $5,000 to $10,000 to $20,000, depending if it's a high net individual or business. And then Chapter 11s are based on hourly rate, so that can be up to $20,000 and more. So it depends on the case, and it's going to depend on the individual involvement in that matter. All right, next slide, please. Okay, so now we're going to go to bankruptcy for entities. The bankruptcies for entities are a little bit different because a lot of times it involves really strategy. In a Chapter 7 for a corporation, what we're doing is basically saying, hey, our company has no money and we have a bunch of debt, so we just want to walk away from the company. The reason a bankruptcy might be suggested is because you have a third party called a trustee. That trustee gets involved in the corporate books and records and it does a full analysis on whether or not this corporation truly has any assets. If it does have assets, that trustee is going to sell them to pay creditors. If there's no assets, that trustee is just going to close out the case and say there's nothing here. Now, a corporate bankruptcy doesn't automatically lead to a dissolution with the state. Once the bankruptcy is filed and completed, then the next step is to dissolve that corporation with the state. Now you might say, why not just file a dissolution or walk away? Well, even if you could file a dissolution, which sometimes you can't because you haven't resolved some issues with creditors, or even if you walk away, that doesn't mean you're out of the woods. What can happen is sometimes the corporation can get sued, and if that corporation is sued, then the corporation is going to need some money to pay for representation, such as attorneys. And it might be more cost effective to file a Chapter 7 and have a third party investigate the corporation before having to deal with lawsuits. So it's really a cost benefit analysis that's done at that point to find out whether or not a Chapter 7 for a corporation is good. It can be used as a stall tactic. It can be used to buy time from a landlord. It can be used to negotiate some kind of settlement even before a lawsuit, because we're able to prepare a Chapter 7 petition for a corporation and give it to a creditor and say, look, this is all we got. You want to go waste time suing us? Go for it, but you're not going to get paid. So these are times where a Chapter 7 might be helpful. Chapter 11, again, like an individual, is a full-blown reorganization of a corporate entity. The goal here is to put together a plan to allow creditors to get paid more than what they would get in a Chapter 7 liquidation. So the goal here is to say, look, if we file Chapter 7, you get nothing. If we file Chapter 7 and we have the ability to reorganize our corporation, you're going to get a little bit more. And what that Chapter 11 involves, it involves all these creditors having the opportunity to vote on a payment plan that the corporation is going to propose, and as a result, create an exit strategy for this corporation. You're starting to see more of the Chapter 11 corporations and Chapter 7 for corporations now because of, I think, COVID and because a lot of companies are suffering. But I do believe a Chapter 7 for corporation is a cost-effective way to go. And then, of course, a Chapter 11 if necessary to help reorganize. Now, one thing that I have to bring up and have to remind people is a lot of companies, a lot of corporations, the individuals that form these corporations do not take note of any personal guarantees they have signed. So for example, if you're a new corporation and you obtain a lease from a landlord, generally what's going to happen at the time you first start that lease is the landlord's going to say, look, this is a new corporation that has no credit. If the corporation defaults on payments, how do I get paid? So he or she then asks that individual to sign a personal guarantee. And what that guarantee says is that if the corporation doesn't pay the rent, we can go after the individual. Now, what the problem with that is, if the corporation chooses to file bankruptcy, that doesn't absolve the personal guarantee. The individual signed the guarantee from liability. So that's something to really pay attention to in the beginning, because if you're going to go bankrupt a corporation, you can't just run away. You're going to have to think of a plan B on how to deal with that debt when it comes to you personally. This could result in your own personal bankruptcy, or this could result in some kind of negotiation at that point, which could help resolve the issues. Okay. A note on the difference between corporate versus individual bankruptcy. Like I mentioned, an individual bankruptcy just applies to individuals and people doing business in their sole name. And then a corporate is an LLC or corporation filing bankruptcy on behalf of the entity only. All right, let's move on. The next slide, please. Okay. Now, some of the things I'd like to bring up, which is more of something you would discuss with your attorney, is alternatives to bankruptcy. Now, during COVID, my biggest concern is having someone or a company file bankruptcy too early. And the reason I say that is because we don't know what's going to happen in 30 to 60 days. What happens if you file for bankruptcy and you didn't really need it, because once the shelter in place lifted, business just started picking up for you? Then you got yourself in this bankruptcy where you have to work with an attorney, work with creditors, pay all these fees, and spend all this time in bankruptcy court that you didn't need to. So it's always nice to kind of, when you meet your attorney, have a plan and say, hey, I don't know if I need this bankruptcy right now. Now, if it's a Chapter 7, most likely you will be, because you've already been at the point where the debt exceeds the assets and you don't have a choice. But now let's say you're kind of at that point where you think if business picks up, you won't really need a bankruptcy, that you'll be able to generate sufficient revenue to get you through this hole. That's something you really want to think about. So maybe it might be worth it to engage an attorney to represent you in a negotiation in advance. And in 60 days, if things don't work, file the bankruptcy at that point. Or maybe in 60 days it will work and you won't need a bankruptcy. So I guess the point I'm trying to make is, right now it's time to be proactive, because we don't know what's going to happen. And you don't want to be too late in the bankruptcy process if you're going to need one in 60 days. At the same time, you don't want to limit your options and force yourself into bankruptcy when there's an option for you to buy time or negotiate with your creditors. So be proactive, create a form of communication with your creditors, and move forward with a plan. And that's something I would say is the most important right now, because of the fact that we can't guarantee the shelter in place is going to stay forever, nor can we guarantee business is going to boom like we thought it would be. So we don't know, and because of that, it's good to have good counsel on your side. Now, I would say it's time to have an attorney on your side, time to have a bookkeeper on your side, and between both of them working hand in hand for companies, you should have everything organized. And then, of course, an individual meet with an attorney also. The walk away. You can't really walk away from debt. Some creditors aren't aggressive, and some are. If you don't really have any assets, then if a creditor sues you and gets a judgment, what are they really going to take from you? If you have no income, you have no assets, it doesn't matter to them. The question is going to be, if you do have assets, what do you do? How do you structure your position where if someone sues you, you have the ability to file a bankruptcy to keep your assets? Those are things that may be something, again, it might be an alternative bankruptcy because you've been proactive and productive on coming with a plan. Another alternative bankruptcy is assignment for the benefit of creditors. This is a more complex kind of a state court process where the assets are given to creditors, and it kind of keeps you away from a bankruptcy filing. That is a limited situation, and I'm not sure the scope of this presentation would take too long to even discuss that. But I would probably focus on at this time during COVID, I would focus on putting together a plan to get out of this situation. And again, like I said, a lot of companies are dealing with their landlords, so you really want to be able to spend time with structuring some kind of process there. Okay. I went through my slides a lot faster than I planned. Does anybody have any questions?
I don't see any questions, but I know previously, Vinod, we had, you'd offered to talk for people within reason for free
Yeah, so
as a
if, you know,
follow-up to this.
right. So this was a pretty short, kind of simple discussion. What I wanted to say at the end was, it's a sensitive topic. It's a hard topic to discuss. And my contact information is there. And, you've been in this presentation. You can email me or call me. And I mean, I'm not going to charge you for initial consultation. Just mention Cupertino Chamber and mention that you were here for the presentation, and we can just bypass that and really have a discussion. And I think a discussion is more important than anything, because there's so many numerous, variables right now where you kind of just need to know what to do and what to think of. So it's more important than anything that we have a plan that way.
Great. We have up on the screen your contact information. Thank you so much for doing this. Double checking. Don't see any questions, but this is certainly one of the more difficult business processes that anyone has to go through. And appreciate your sharing about how to best navigate that process. If We do have requests. Are you able to share your slides with people?
Sure.
Okay.
Okay.
And we'll certainly do that. And for people who want to revisit the presentation, that will be online by early this afternoon for reviewing. And with that, I think we want to say thank you, Vinod, and we very much appreciate your time and expertise. And
Thank you.
have a good day. And to all of our participants today, thank you. Be safe, and here's to a successful rest of the year.
Thank you so much.
All right.
Bye-bye.
Take care.